King versus Burwell is going to be this term's big challenge to the Affordable Care Act. And in this case, it's really the text of the Affordable Care Act against an interpretation that the IRS has of that text. The Affordable Care Act says that the subsidies are available, and if you purchase a plan in an exchange established by a state under Section 1311. And the IRS has interpreted that to mean not only exchanges established by a state, but also exchanges established by the federal government. Because as people weren't really predicting when the law was passed, but as has happened, 30-some states have decided not to actually establish exchanges. So we have a majority of states that don't have exchanges, and so in which subsidies wouldn't be available. That means there's probably about 5 million people who, under the text, the plain text of the Act, are not eligible for the subsidies that the IRS wants to give subsidies to as well. The other implication of the law is that in those same states, another 8 million people, and then it would be subject to the individual mandate because the subsidies are available. And another 57 million would be subject to the employer mandate because of those subsidies available. So either way the court comes out, there's going to be millions of people involved, and it makes it very difficult for individuals to know how to make their health care decisions, for employers to know what they're required to provide, whether they're going to have to be taking measures to economize either by cutting hours or by cutting employees in order to be able to meet those obligations, for the states to know how they're supposed to be administering things. So there's a lot riding on this, not to mention the insurance industry not knowing what types of plans it even needs to be offering in some of these states. So I think it'll be good to have the Supreme Court establish this as a national rule now, so that everyone else can go about their business of trying to make these important health decisions, knowing what the state of the law is. And at the end of the day, this is a very important statutory law question. What kind of authority does an agency like the IRS have to interpret or even rewrite the text of a statute? And that's going to be the big argument. Is this merely an interpretation, saying that an exchange is established by a state also includes federal exchanges? Is that simply interpreting the law one way, or is this really usurping the power of Congress and rewriting a statute? And we know, of course, the statutes can only be amended by Congress and signed by the President. So there's a real question of the constitutional structure of government that's at issue here.